Good morning, everybody, and welcome to August risk reduction, risk management class, where we're going to be talking about three topics. And I think two of the three will affect almost everybody, and maybe the most important subject of today's call will affect most of you sooner or later. So the first topic we're going to talk about in detail is selling a property owned by a RE/MAX Connections agent, or his or her relative, or his or her business entity. As I had mentioned in the office meeting, we just recently placed our new E&O policy in place, and that was quite a challenge to get that kind of a transaction covered by E&O. And I talked to, we went to 7 different companies. I actually had communications through our agents. We have a couple of agents working on it with 5 companies. And it was a challenge to finally get something that we could live with. And so I'm going to review that with you today. The second thing I'm going to cover briefly, and that is when you represent a buyer who buys a flipped property, what to keep in mind regarding that kind of a transaction. And finally, I want to talk about insurance claims. There is still, from time to time, issues with properties after close of escrow that had insurance claims, and sometimes the documentation in the file is not as good as it could be. And so I want to talk to you a little bit about that as well. So those 3 topics. So let's jump right into the class. Let me share my screen, if I can remember how to do that. There we go. Yes. Share. There we go. Can everyone see my screen now?
Yes, we can.
Excellent. Okay, thank you. And let's get to the presentation. All right. And as always, of course, any questions, anytime I can help you with any transaction problem, call me sooner rather than later, but call me anytime you think you should. The best way to reach me during business hours, I'm working on shifting into a cell phone mode, but I'm having some challenges with my brand new Apple 13. So I recommend still calling the office during business hours. The direct dial is right there on the screen. That rings right at my desk, and I'll return your call if you get the voicemail. Of course, my email address is on the screen there too, Walter@remaxconnectionsca.com. And evenings and weekends, of course, you know, the cell is the way I communicate with everyone. It's probably better to text me. You're welcome to call me, but the texts get my attention quicker. The phone lights up when I get text messages, and I keep that phone within eyesight all weekend long. And I will check the voicemail too, but text me and then leave me a number or tell me you've left me a voicemail. I'll get back to you, of course. All right. And if you end up calling me at the office on my cell, I'm learning to monitor that a lot more than I used to. All right. So let's talk about selling your own or a relative's property. And for simplicity's sake, I'm not going to continue to repeat or a business entity owned or controlled by the agent or relative. That's the third leg of this 3-legged stool, if you will. Your property, your relative's property, or a property you or your relative have an interest in through a business entity. So we're going to talk about that. And like I said, the E&O companies all gave us quite a bit of trouble. There's been tremendous losses because everybody and their brother, you know, has gotten on the bandwagon flipping properties. We happen to have several agents in this company who have flipped properties for a long time. And I'm happy to say they do an excellent job. They're very professional, ethical folks. And once in a while, when we do have a problem with a buyer after close of escrow on a property that one of our agents flipped, we can always resolve it. We have in the past. My concern, of course, is why do you have insurance in case you can't resolve the problem? You know, you hope you never need it, but when you do, you want to have it. You know, many of you know this former, 2 owners ago was sued. The company was sued for $4 million, and the insurance on our behalf paid out over 700,000. So imagine not having E&O coverage and that problem pops up. And that was with an agent no longer with us who done a ton of real estate. So you just never know when something, you least expect it bites you and you have a big problem. So when insurance companies all, told me and sent their original proposals to us, and they were omitting what they call flipped or agent owned properties. Flipped is any transaction within 1 year of the acquisition. So whether you fix up the house or not, it's considered a flip by the insurance industry if you own the property for less than a year. You could buy a brand new, beautiful home, sell it, 3 weeks later, they're going to call that a flip. And, generically, they want to exclude all of that. They also want to exclude agent-owned properties wherein the agent represents himself. And that's always a problem from my perspective. And I think those of you who have sold your own properties will agree. One of the benefits of having a license is you can buy and sell properties. And there's a little bit of a financial benefit because you can wrap commissions into that. And so suddenly you've got to pay a commission to somebody else to represent you on selling your own house. That's not a good situation to be in. And we've always struggled with that. We've in the past been able to get provisions in our E&O to allow that. It got very difficult this time, but the good news is, yes, we can. You can represent yourself. You can represent your relatives. You can represent your business entity in selling a property. There are, however, caveats. So the first thing I want to review with you, and all of these forms are in Agent Hub. They're in your handout. I'm going to show you how to get the forms out of Agent Hub for those of you who aren't as familiar with Agent Hub as some of you. Some of you have been using Agent Hub since its inception, and some of you have not yet gotten to Agent Hub, don't even realize what a beautiful benefit it is. When Mike bought the company, I honestly think even more than some of the people, including me, that he was pleased to bring into the fold. He was thrilled to have Agent Hub. I mean, Agent Hub was just fantastic, and so he got bought into that immediately, and immediately proposed a lot of improvements to it. And Lindsay has been working hard on it, for more than a year, bringing it up to some of Mike's expectations. So it's a wonderful place to go to, and this is where you'll find all these forms, and I'll show you where to go. So let's go through these instructions because this sort of details what you have to do, and we'll go through them paragraph by paragraph. So as I said, our E&O company has specific requirements when we sell a property we own, or a relative owns, or a business entity owns. And they define relative very broadly. Take a look at the screen, look at your handout. A relative is just about anybody that has any connection to you by blood or marriage. So direct relatives are defined as parents, grandparents, siblings, aunts, uncles, cousins, children, your spouse or domestic partner, your spouse's or domestic partner's parents, grandparents, siblings, children, including step relations and relations by adoption. So you can see it's pretty broad. So if you end up representing an uncle, then these policies we're going to talk about today have to kick in. If you end up representing a cousin, these policies should kick in, because E&O will deny the claim should there ever be one. And of course, the biggest concern, very few claims are made against buyers, claims are made against sellers. And so we're talking about when you are selling a property owned by you or your relatives or your business entity, the likelihood of a claim being filed is not because you're doing it, but just because you're a seller, and all sellers run the risk of claims being filed against them. So that's the first thing. Now, E&O insurance, normally we have a $10,000 deductible, And if we'll cover we'll cover the second half. Let me explain that. We'll cover the second half if you attend these monthly classes and follow the guidelines that the company lays out as far as doing transactions. If you don't, then you're at risk for the entire deductible. The deductible for agent-owned transactions is a $20,000. And again, if you follow these things, the beauty of this guide that I'm going to give you is it's going to truncate claims practically from the very beginning. Just like I talked about last month, the BMI is so powerful because it ends any claim almost at the get-go. Following all of the processes I'm going to talk about now will also, end any potential claim early in the process. And so, you won't have to worry too much about the deductible because if you're following the processes, you will defeat any claim. Okay, so the first thing, let's go through them line by line. The first thing, this is critical, a written home inspection report issued by ASHI, CREA, NASHI, or NAHI, I will say it all right, a member inspector. So these are all certification people. ASHI and CREA are the two most common ones. The property has to be inspected by one of these inspectors, and that inspector must be providing the inspection report directly to the buyer. Now, who pays for it is not critical. Usually buyers pay for their own home inspection. What is critical is you have a home inspection from a previous transaction and it falls out of escrow, and now you have a new buyer. That new buyer has to be the person who is hiring, not necessarily paying for, but hiring the home inspector. So any questions on that, put something in the chat and I'll go over it a little more detail, but that's very important. Okay, the next thing is an approved home warranty must be in place, and we'll talk about that in a little detail in a minute. And just about any warranty company is approved. A CRES affiliated home warranty will reduce your deductible by $5,000. So that might be something to keep in mind. The following car documents must be completed and, completed properly and provided and acknowledged by the buyer. And I want to make a point to you. We're pretty lenient, believe it or not. Lindsay does a great job. Holly does a great job. Once in a while, our agents drop the ball and nobody bats 1,000. Nobody's perfect. I'm certainly not near perfect. So, do you forget to do something once in a while? Of course you do. Are we going to cook you? No. Are you going to boil you in oil? No. Are we going to pay you? Yes. If you forget to do one of these things, they're not going to cook you. They're not going to boil you in oil, but they're not going to pay your E&O claim. So if the file is lacking any of these when they're supposed to be in the file, that will be grounds to deny coverage. So you want to pay attention to it. And there's nothing here that you shouldn't be doing anyway. So an agency relations disclosure from the and I thought I updated this slide. I thought for sure I did, but I guess I didn't. An agency relations disclosure from the listing firm to the seller and from the selling firm to the buyer. So that's in your handout. And Lindsay reminded me to update my PowerPoint. I thought I did. So it's not just the listing firm to the seller. It's also the selling firm to the buyer. And that's going to be a little bit of a challenge because we no longer need the other party's agency disclosure. Civil Code doesn't have that. I'm trying to get that removed. I'm not 100% certain I will be able to, because they want the buyer, they being the E&O company, want the buyer to know, who their agent is. And Civil Code says that in order to be informed about who your agent is, you have to know what the definition of an agent is. And that's what the AD does. The AD has to be given before an agency confirmation, or the agency confirmation is invalid. So that's something to keep in mind in general. Don't ever drop the ball on the AD. All right. The affiliated business disclosure, they want that, of course, and we want that. The real estate transfer disclosure statement completed. Of course, that's a part of it. The agent visual inspection disclosure, if and again, these if appropriate, then they must be provided. A trust sale, of course, wouldn't require one. But these others, normal 1 to 4 residential units, those would be required. An SPQ, that must also be a part of the transaction. Again, nothing new here. Oh, here's my here's my corrected slide. All right, there we go. I didn't delete the old slide. So a little review there for you. All right, number 6, fire hardening and defensible space advisory disclosure and addendum, if applicable, and that, of course, is if it's in a high or very high fire zone. A lead-based paint and lead-based hazard disclosure, the LPD, if it's built prior to 1978. The residential earthquake hazard report signature page, if it's built prior to 1960. These are all required by civil code. They're required on our broker file checklist. I want to stress, if ever you forgot to do one, I sure wouldn't forget to do one on a property you own that you're selling, or your relative owns that you're selling, because that could have much more severe consequences. All right. A statewide buyer and seller advisory, the SBSA, and a qualified substitute or a FERPTA. All normal things that you should have in every transaction anyway. And then the third thing, it's not a CAR form, so that's why I separated it. It's a natural hazard disclosure report and the signature page, it's signed and acknowledged by the buyer. So that, the NHD, that's, obviously folks are aware of the fact it's not a CAR form, but it is a form that must be in the file. A complete list of all repairs and improvements done to the property by the agent or whoever the agent hires to repair the property. So that list of what's been done should be provided to the buyer. The properties involved is 1 to 4 residential units. And the file includes a RE/MAX connection supplement to the real estate purchase agreement, and that's available in Agent Hub. We're going to go through that next, and then I'm going to walk you through getting these things out of Agent Hub. Our E&O carrier does allow dual agency. However, dual agency, of course, agency is broker specific. So they do allow RE/MAX connection to represent the seller, of course, who owns the property, the agent, and you're probably representing yourself, and the brokerage is representing you. They also allow a brokerage to represent the buyer of your property, but they want a different agent working with the buyer. And so that's the key. So if you have a buyer lead on your own listing, you want to make a referral, talk to me, talk to Larry. Possibly we can accommodate that by having another agent, or you could just refer it to another agent. That might be a simpler and cleaner way to do it. Get a nice referral fee, and then the other agent is just working with the buyer. A little side note here. You want to be careful when you're talking to your clients about dual agency. Here's a mistake that some agents make, and it's not intended to be inaccurate, the statement they make, but it's very inaccurate, and it can cause problems later, because the buyer could say, I was told that my agent only represented me. Here's what sometimes a buyer's agent or a seller's agent will say. Yeah, I represent you, Mr. Seller or Mr. Buyer, and Sally represents the buyer. I don't represent the buyer, Sally. And of course, Sally is a RE/MAX Connections agent. Well, that's not true. Civil Code says that if anybody in this company represents any principal, everybody in this company represents that principal, believe it or not. It's broker specific. So you should not be saying in dual agency, yeah, I represent only you, and the other RE/MAX agent from the other office, they represent only the buyer. No, that's not true. Don't say that, because if we had a problem later and you were put on, were deposed or put on a witness stand, you would have created a serious problem, because if there is non-disclosed representation or inaccurately disclosed representation, that is a serious compromise to our ability to defend the claim. So the phrase "works with" is what I always tell agents to use. So a buyer represented by another agent in our company, don't say, "Oh no, I'm going to represent you only, and Sally from the other office is going to represent the buyer only." Don't say that. Say, "I'm only going to be working with you, and Sally's going to be working with the other agent." You know, it is dual agency. Remax Connections represents both, but I will be working with you. Again, working with you, that's the key phrase. All right. So the Remax Connection supplement to the real estate purchase. This form, I developed this form years ago when we had a similar problem with an E&O company that would not allow agents to represent themselves. And so we had straw agents where we would name somebody as the agent, but that person would never, ever appear in the transaction. There was a claim made in the transaction, and during the deposition, the so-called straw agent was mentioned, to which the other side said, "Who's that? I've never heard of that person." And the E&O darn near denied that claim. Well, they did end up covering the claim because, we got them on a catch-22, so that helped us. But they told me they're not going to cover it again, and I told them we have to fix that. So we fixed it by developing this form. And so that worked quite well. When the new E&O companies were telling us, "Nope, don't want to do it," one of the things we submitted to them was our track record and the way that we handle agents representing themselves in transactions and this form, and they liked it. They said, "That's good. As long as that form's a part of the deal, all right." This form, by the way, there are a few agents that like this form so well, they use it from time to time when, it has nothing to do with an agent-owned property, because it protects you from buyer claims quite well. So here's the form. So that's the picture of the first page of the form. It's a 3-page form. And of course, it's got the property address. It names the buyer and the seller. And then it talks about that the buyer satisfy themselves with the condition of the property and get any inspections to the property that might be of concern to them. And then they initial items 1 through 11 so that they have been specifically advised of these specific inspections. So the physical inspection, we talk about that, and of course that is required anyway. And then we talk about other inspections that are not required, but could be a good idea for the buyer to have. What we want to do is to be able to say, look, the buyer was advised that he could have got the inspection. He didn't. So any problem with the roof is on the buyer. There is a contract principle, and our RPA has that as well. And that is the buyer has an absolute legal obligation to mitigate any damages they might suffer. Mitigation means minimizing damages. Well, the most obvious way to minimize damage, if you buy a house with a bad roof and you didn't know it, well, the way to minimize that damage to you was to have the roof inspected during escrow, so you could either have the seller replace the roof, repair the roof, or you don't buy it. So, that's mitigation, very important. So we want the buyer to proactively be aware and acknowledge that these inspections are available to them. And we want the buyer's agent to walk the buyer through the form. So the buyer's agent initials and then the buyer's initials. And so it's the same with mold. It's the same with environmental inspections. Pool inspection. Pretty obvious what all these things, why these things are on this list. Soils, geological, structural inspections. This bottom of page 1 and the top of page 2 has the paragraph 6. Paragraph 7, septic inspection. Permits and zoning, it's always a big issue, quite a bit of discussion there. And again, the buyer is advised of all of this, and they initial right here. Pretty hard for them to say, "I didn't know, my agent didn't tell me." And remember, when an agent is selling his own property, the presumption is that the agent might be cutting corners somewhere to make sure the deal goes through, and they want the buyer to be fully informed of all the options available to them. Square footage, lot size, boundary lines. pet urine stains and odors. We've had a couple claims, by the way, with pet stains and urine odors. So that's not a inconceivable problem. And then finally, the last paragraph, we don't make any verification of the condition of the property. And that's, the brokers and the agents don't make any representations, either expressed or implied, or nor do we make a comment regarding the information made by the sellers. So then there is a advice against waiving any inspections. The buyer initials that. And then there's a section where the buyer and the seller acknowledge and agree that what the broker will not do or cannot do. We can't guarantee the condition of the property. We can't be responsible for defects that we didn't know about. We're not responsible for defects that aren't visibly observable, because that's the only inspection we make of the property, a visual inspection. We don't identify property boundary lines. We don't provide legal or tax advice, or provide other information that exceeds the knowledge, education, or expertise required to obtain a real estate license. So we want all the parties to acknowledge that that's the case. And then the buyer elects which inspections they want to have. Now, sometimes this form needs to be filled out early in the transaction. And so sometimes the buyer doesn't know. So the default is initial it. Just say you want it. And you can later remove that, and I'll show you how to do that with another next form. Or they can waive inspections straight out. Now you notice all the inspections are listed, except the physical inspection. That is not waivable. There's been a couple times where an agent, one of our agents, has had a good reason to say, is it really necessary to get a physical inspection on this property? And we've gone to the E&O companies in the past, and they've always said no. So we don't make it waivable. I'll show you how to enforce that in a minute. And then the buyer and the seller sign and that they acknowledge and get a copy of this. So that's a 3-page document. Now, sometimes they elect to get an inspection and decide not to get it. And so if they elect any inspections on the supplement that I just covered, and they're not going to get those inspections, and you're going to know they're not going to get them, for the most part, they're going to tell you perhaps, but they don't provide you one. I'm not getting a mold inspection after all. Okay, well, you said you were going to get one. So we need to then modify the supplement with an addendum to the supplement, which is this form here. And again, the top of the form, pretty straightforward. And then again, advice regarding waiving an inspection. And then we list the things the buyer originally said they were going to get. And they were going to get a mold inspection. So we go back to the supplement. You go back to the supplement and you check mold inspection, because during the escrow, they said, no, we're not going to get one after all. Or no, we're not going to get a pool inspection after all. Or no, we're not going to do a zoning and permits and zoning inspection. Okay, so you list what they said they were going to get. And then the next thing is they acknowledge they're not getting it. So they initial, they say they're going to get a mold inspection, but they're not. So by initialing they're electing to waive that inspection after all. It's sort of it's the same vein as a BMI. If a BMI says there's something that they're concerned about, you've got to document that is no longer a concern, or they've satisfied themselves. So same here. If they say they're going to get one of these inspections, you got to document. When they don't get one, you got to document they no longer want it. And then again, buyer and seller sign it. So it's a pretty straightforward form. You may not need it all the time. Okay, now, here's an important point, and this is critical. There is absolutely no legal requirement for a buyer to do our supplement. There's nothing in the law that says they have to do it. There is a legal requirement for the seller to give the buyer a TDS and for the buyer to acknowledge that they got the TDS. That is in the law. Usually any car form you give any of the other side, they're usually going to respond. Not always, by the way, but usually. Frequently, non-car forms, other sides will say, no, we don't sign them. We, in RE/MAX Connections, if you get a non-car form that you have any question about, you should send it to me, because there is a habit by some companies to include waivers in their in-house forms that may be problematic for your client. So from time to time, in fact, just recently, I apologize, I forgot who, 2 days after somebody talks to me, I forget most of the conversation until you remind me of it. Then I remember right away. That's why I take notes. But a couple of days ago, an agent sent me a document that they were asked that the seller provide, sign that. And it was an in-house form. I went through the form and it was very acceptable. And I told the agent and the TC, yeah, that's fine. And then I commented that good that you checked, because sometimes these in-house forms are problematic. I specifically do not make my in-house forms problematic, with the exception of this supplement. This supplement contains waivers. Why? Because the E&O requires it. So what's my point? My point is we've got to compel the buyer to do the things the E&O company is going to require to ensure the property. So just like some forms, a buyer does not have to execute. A buyer does not have to get a physical inspection. There's no law that says that, unless contractually they agree to do it. So I hope you understand that point. And if you explain to the other side, the reason we're requiring this is so that the transaction's covered by E&O. If you don't do this, then we won't have coverage, and that could be very problematic for everybody later. See, buyers and buyers agents are going to want the seller to have E&O because that's a source of payment for a claim. They don't have to chase the brokerage around, the agent around. The E&O will pay it if they prevail in their claim. So people only do things for their reasons, not yours. So if you simply say, I need this because my E&O won't cover me without it, yeah, they may give it to you, they may not. If you say, look, I need this and you're going to benefit from it, because that way the transaction's covered by E&O, and should there ever be a claim, God forbid, I hope there isn't, but if there ever is, your buyer will have a source of payment if they prevail in their claim. See, that's how you spin it, if you will, to a benefit to them. All right. And there's nothing unethical about that. It's an exactly true statement, what I just said. Now, what we don't want to do is be relying on our ability to convince the other side to cooperate with some of these requirements that are not in the civil code. So how do we do that? We make it part of our counteroffer. When we receive an offer from a buyer, it's not likely that offer is going to say that the buyer will get a physical inspection from a certified inspector. The buyer will complete the supplement. Not very likely the buyer's offer is going to say that. So you're going to have to counter this. This counter is in the Agent Hub as a template, so you can see it's pretty simple. Basically, there are two things you can do at the top of the form to get these things a part of the contract. The first is you can actually write as your first term in the counter, addendum number 1, which I'm going to review in a minute, is incorporated into and made a part of this counteroffer or seller's multiple counteroffer. And you can also check the box. Addendum number 1 is part of the counteroffer. All right. Now, what's the addendum? Well, the addendum is where these specific things are listed. And I put it on an addendum because it's pretty wordy, and I didn't want to fill up your counteroffer, all the blanks, because you are going to need room for price and escrow and, close of escrow changes and all that kind of stuff. So, it's a little cleaner way. Scripps Ranch, Escondido, and Fallbrook agents who've been selling their own properties have dealt with this system for a number of years, and I think we've worked out all the bugs. So here's the addendum that you're going to attach to your counteroffer as a part of the original negotiation. For you to accept this buyer's offer, this buyer's got to agree to these terms. And so what are the terms? As a condition of this sale, the buyer at the buyer's expense shall have the home inspected by a professional home and property inspector who is a member of one of the following associations. And there they are. We've had buyers change their mind after signing this, and we've been able to get them to get an inspection because we said, no, you agreed to it. It's in the offer. So you need it in the offer or the counter offer in order to enforce it, because otherwise you have no leverage whatsoever. All right. We also want a 1-year warranty in place. Now, there I don't in the counter, in this addendum, I don't talk about who pays for it because that's probably already in the offer. But I do state that it has to stay in place for 1 year because we've had problems in the past with buyers canceling home warranty after close of escrow and attempting to be refunded the premium. So, we want that in place. So it's pretty straightforward here. And then finally, very important, within the time specified in 3L3, which is the investigation of the property contingency period, the buyer and the buyer's agent shall execute and return to the seller the fully executed RE/MAX connection supplement to the real estate purchase agreement, which you can attach this counter offer, and you probably should, just a blank one, filled out on the top perhaps, but remember, the buyer and the buyer's agent is going to be doing all the initialing and everything. And that's the form we just reviewed. So now with this counter offer, we are compelling the buyer to do the things we need them to do so that your transaction is covered by E&O insurance. All right. Now, how do you get this stuff? I mean, you're listening today, you're taking some notes, I hope, if you need to. But 3 months from now, you're going to have forgotten some of it. That's normal. That's, the way the human brain works. So you go to Agent Hub and you get all of this. And so how do you do that? Most of you know this. I'll go through it fairly quickly. So accessing these forms in Agent Hub. So Agent Hub, the web address is agenthub.remax.com. No dots. Someone a long time ago told me that you can capitalize words within a line and it won't mess you up and it makes it easier to read the line. And I've kind of taken advantage of that here. So make a note of that. If you haven't been to Agent Hub, how do I get to Agent Hub? How do I get to Agent Hub? You just open your browser and type in agenthub.remax.com. And when you do that, it'll take you to a landing page. All right, that's the first screen you're going to see, and you have to log in because it's a secure website, site. All right, so the first thing you do is your username. Now, this is important because there's a lot of misinformation from time to time. People mean well. Typically, a username will be your name or an email address, right? And it even says this, or email address. Your email address will not work here, but it's easy. It's your first initial and last name. Mine would be W. Klein. Lindsay's would be LKD. David Close, not to pick on David, name just pops in my head, would be D Close. So everybody, it's your first name, initial, last name, word, all one word. And then your password. Password's real simple also. And you don't change the password. The password is defaulted into the system, but it's easy. It's the number 5 in front of the last 4 digits of your social security number. 5 and then your last 4. Now, for the agents that are in Scripps Ranch, Escondido, and Fallbrook, it's your copier code. It's the same thing. So 5 and your last 4 of your social security. You type those 2 things in. You can check remember me if you want. It's not necessary. You will get to the landing page. Here's the landing page. Lindsay and Mike has suggested a lot of improvement over this past year, and Lindsay has worked hard with our webmaster to get all of these things incorporated. And this Agent Hub is just better and better all the time. So one of the things you want to go to, by the way, look at all the different things you can click on, but I don't want to spend a lot of time on everything else, is Docs, Forms, and Contracts. So you click on Docs, Forms, and Contracts, and it will take you to Docs and Forms. Now, I just point out, I've prepared some clauses for specific situations that you come upon from time to time, and I put those clauses and an explanation of how to use them. I didn't do it. Lindsay did that for me. Put that on Agent Hub. So, look at that sometime. And then there's other information here. You want to look at contracts and forms, right? You click on that. And it's going to take you to a page where all of the RE/MAX connections forms are located. And you're going to want to maybe sometime take a look at it because there's some pretty interesting and useful forms there. One of the forms we require is the addendum to the disclosure, the agency disclosure relationship. So that is available on Agent Hub. Right now, because we're talking about selling your own property, you're going to click on Lindsay organized all of these forms for selling your own property or your relative's property or your business entity property in one file, so you don't have to hunt all over Agent Hub to find them. You can just click on this file and it will open up these forms that I've just reviewed with you, including a sample of the counteroffer, and then the addendum itself. Now, I didn't click on the addendum. I probably should have, but that's okay. I did click on something. You click on something and you double click it. What will happen is it will open it up in this window, and then you can print it right there if you want. You can download it to your computer. The addendum, Lindsay has made that PDF, I don't know what they call it, interactive or something. She's created fields on that addendum so you can fill it in and then export that right into Zip Forms or DocuSign or whatever. If you have any questions there, I'm going to put Lindsay on the spot here. You give Lindsay a call, she'll guide you through that. But you simply go up here and either print them or you download them. Yeah, I don't think I'm almost certain, I'm almost certain you cannot fill in the addendum while it's in Agent Hub. You have to download it, and then once you do that, those fill-in fields, just like car forms, you can type right into them. And so that was an improvement. And for everybody, those of you who are familiar with this form, you weren't able to fill it in, but Lindsay was volunteered to fix that for us and make it a little easier for you to use these forms. So that's how you get to Agent Hub. And that's where you get all this information. All right, let me talk about the other two things here. And we're going to finish a little ahead of the hour, which will give us a little time for questions if you have any. So the second thing I told you I want to talk about was representing buyers when they buy a flipped property. And in this case, we're using the word flipped for the more typical meaning, and that is the seller rather, has bought the property with the intent of fixing it up and then selling it with the intent to make a profit. So sometimes we represent buyers when and we're not the seller, and there are still problems with some of these transactions. By the way, I can tell you, and I'm very pleased to say this, and I mean this sincerely, all of the flippers on this call, they're excellent at what they do. They do a great job. They're honest. They have integrity. They stand behind what they do. And we don't have a lot of problems with buyers buying our flip properties. I mean, you always have a question or a little claim or this or that. One time we had a kind of it wasn't really hilarious, but it was kind of, who would ever believe that would have happened? But the agent involved stepped right up to the plate. The agent put a fence in, and they put one of the fence posts right through an underground electric vault. And nobody knew about it until it rained and the water got into the vault and shorted out the vault, which shorted out the electric to the house, which the buyer was away for the weekend, and all the food in his refrigerator and freezer froze or thawed, rather. I honestly believe that he didn't have that much food in his freezer and refrigerator. Who had, but maybe they did. I don't know. Maybe they're preparing for World War III or something. But they had this big long list of frozen food that they wanted replaced. Our flipper didn't hesitate. Once we determined that it was a mistake that we'd made, we took care of it. So that's the good news. So you can always, with those of you that have the opportunity to sell one of our agents' listings that they've flipped, you can have a certain sense that you're not going to have to be as worried about what I'm about to talk about as you will buying a listing from, Flips R Us, and now your buyer is stuck with a lemon of a house, and how could we prevented that? So that's what I'm talking about here. I'm not talking about buying our agents flipped properties as much, because they're going to follow these procedures anyway. So, all right. So now when Lindsay put this put out the normal reminder, you all got the reminder yesterday, and Lindsay did a tremendous amount. I want to acknowledge how much she helped me with this presentation, because as you can see, there was a lot of work with Agent Hub and in-house forms and a lot of typing. I'm the world's slowest typist, and not very good at speed and accuracy at clerical functions. So Lindsay was spending a good part of her day helping me put this class together. And at the end of the day, of course, I had scribbled on a sheet of paper what I'd like her to put on the memo. And it's amazing to me that she can even read it half the time. I sometimes will read it along with her, and she has to rewrite it. Well, the writing of the memo, she couldn't read it really well. And so we'll talk about preparing buyers when they buy a flip property. And I told her, oh, no, that's supposed to be representing buyers. But then I thought about it. That ain't a bad statement to make, because the very first thing you should do when you're representing a buyer of a flip property is you should prepare the buyer. As the buyer's agent, you should review with the buyer the importance of getting inspections, And the fact that the flipper may not know the history of this property. It's not like buying a property from mom and pop seller who's lived in the house for 10 years or 20 years or 4 years. This flipper's never lived in the house. He doesn't know anything, and he doesn't care when he bought it. He just got it for the best price possible. She paid as little as she possibly could. Nothing wrong with that. And then they're going to fix it up enough to sell it. So you should talk to your buyer. You should prepare the buyer when they're buying flip properties. It's not the same as buying a property owned by the seller who's actually living in the house. So Lindsay's, what I first thought was a typo was actually, very pathetic. I can't think of the word now, but it proposed what should be thought about. Prepare your buyer. Repairs and improvements may only be cosmetic. The house is going to look great, but that doesn't mean it's a brand new house. And there may be some serious problems that the seller, the flipper, either didn't know about or didn't address. It's not like you walk into a model home and you pretty much assume there's nothing wrong with this house. And if there is, you got all kinds of warranties in place because it's a newly built home. The flipper wants it to look as newly built as possible, but it's not. So a little discussion with the buyer about this from the get-go is not a bad idea. And then, of course, once you open escrow, then it's important during the escrow to get disclosures and reports from the seller that the seller received when the seller acquired the property. So there will be some information about the house in some of those reports and disclosures. And typically, flippers aren't as conscientious about providing that as, say, agents in our company are, because you all know, gee, if it's, if it was bought within 3 years, then all the paperwork, all the disclosures, not all the paperwork, all the disclosures and reports must be provided to the new buyer because we have them in our possession and those are material facts. So when you're buying a flip property, you want to make sure during the escrow you get the reports and disclosures the seller got when they bought the property. You also want to get details regarding what repairs and improvements the flipper actually made to the property after the seller acquired the property. That would include the seller and all of the handyman, employees, and contractors and subcontractors that the seller caused to have them work on the property. And then finally, you want who did the repairs and improvements, name and contact information. There may be civil warranties, civil code warranties that the buyer can benefit from, but you won't be able to take advantage of them if you have no clue on who did the plumbing repair or who put on the new roof. So you want that. So that's important to get that information during escrow. And during escrow is the key word. These issues should not be addressed during the offer counter process because you will scare off the flipper. You start saying, well, I need a list of all the improvements you did. I need a list of all their subcontractors. The flipper is going to pick another offer. So I would not raise these issues. Previous slide, I wouldn't discuss that in any detail when you're trying to get your offer accepted. Those are all material facts that must be disclosed in the transaction. I've advised many agents not to worry about it during your offer because your goal right now is get the offer accepted. Then if you don't get this stuff, call me, I'll get it. And I don't want to jinx myself, but I can't remember not getting it. Usually you get it as well. Usually flippers, they're not all out to cheat anybody. So usually they're pretty good. But if you do deal with a flipper that, and some of them do have reputations. We've got a couple of legal issues going on with flippers. The attorney world knows these flippers. So they're not us. That's the good news. So deal with these issues after your offer is accepted. They're going to be addressed as part of the seller's disclosure after the offer is accepted. So that's a simple outline of representing a buyer when they buy a flip property, and especially when it's not a RE/MAX Connections flipper, because like I said, RE/MAX Connection flippers are going to follow a pretty decent procedure anyway. Now, disclosures to provide and get when the property is the subject of an insurance claim. This has come up again, and it's come up several times over the many years. And so I want to just clarify something that some of you probably know, and it's going to be obvious. you have to think about it. Otherwise, you end up with not adequately making or getting disclosures regarding an insurance claim. So what am I talking about? What I'm talking about is that when a property is subject to an insurance claim, there are really two sets of disclosures that should be given or obtained. And by sets, I mean, I put that in quotes. I didn't know exactly what word to use. Sets work just as well. There's two groups, there's two types of things, whatever. And you'll see what I mean in a minute. The first are details regarding a claim itself. All the insurance claim paperwork. That's usually what you get right away anyway. Okay. Yeah, we filed a claim and here's this form and here's that form. I have seen insurance claim paperwork made as a disclosure that could fill a file folder, a half-inch thick stack of paper, literally 100 pages of information and detail because the claim was somewhat significant. So a lot of insurance claim paperwork, and usually you get that. You want to ask for it. And you also want to get a statement regarding the event, what happened and what damage was done to the property. See, that's the claim itself. So you want the insurance paperwork and you want a statement from the seller. Sometimes they said, yeah, insurance claim, water leak. Well, you want more details. Where, what was destroyed, that kind of thing. That's part of the claim. Now, another part of it is, in other words, what happened? Another part of the claim, but it's a unique set of paperwork. And this is the paperwork that frequently isn't provided or asked for. What repairs were actually made and who made them? Sort of think of it this way. Typically, now there are exceptions, and that's what's going to make the rule I'm going to give you accurate, because there are exceptions. Insurance claims on real property is almost like insurance claims on clunkers, automobiles. If you have a banged up automobile, but you have insurance on it, well, you have to have liability insurance. But if somebody hit you, even if it wasn't your insurance company, they're typically going to write you a check. They're not necessarily going to make the repairs on a clunker. They'll make the repairs on your new car because you want the repairs made in your new car. You want them to deal directly with the dealer. But on a clunker, you have, $500 worth of damage. You'll write you a check for $500, and you do whatever you want with it. If it's a clunker, what is the owner of the car going to do? Put the $500 in the bank and continue to drive his banged up, rusted out car anyway. So insurance companies on even $100,000 plus claims do not pay contractors directly as a rule. They can and they will sometimes. Sometimes they don't want to. They're going to get estimates. They're going to do their own in-house adjustment. And if you provide them quotes, and then they write a check. My son had a on the property damage alone on his house was $70,000. Had a water leak. It leaked all night. Didn't know about it until he got up in the morning, and there was 6 inches of water, literally, flowing out the back door. Maybe not 6 inches, but more than 3 or 4 inches. It completely, a little mini pool, his entire downstairs. So they had to gut the entire downstairs and start from scratch. My son hired all the contractors and took the insurance checks and paid them. He also upgraded the house, and so it was a win for him. And the insurance company paid rightly what was damaged, and he added to it to fix the house the way he wanted it. And that was a claim that was on the water damage alone was $70,000. And they don't necessarily hire the contractors to pay the contractors, but they give you a very detailed accounting of what they're paying for, because they got to justify that. So what you want to know is, what repairs did the seller actually make with that money? And then you also want to know who made them. So you want a statement regarding the repairs performed. You want receipts for the repairs. You certainly want to ask for them. And you want who made these repairs, name and contact information. So that's why I'm saying it's sort of a two-part disclosure. You get the paperwork on the insurance, but you also want to know, what did you do? We had a situation one time where more than $100,000 was paid to the seller, and the seller paid only about 25 or 30 grand for repairs, because a lot of the repairs the insurance company paid him for, the contractor he hired was a friend of his, that he said, you don't need to do this. You can live with that. Yeah, that's okay. Don't worry about it. after the buyer bought the house and lived there for a year, she had a problem with one of the things that wasn't fixed. And she wanted to, go after the insurance company because they fixed all this. Well, no, they don't fix it. By the time I sorted it out, this buyer, and by the way, we were dual agents. This buyer got all of the insurance paperwork, none of the contractor receipts, what was done paperwork. So the buyer is looking at 100,000 item. For example, just to make my point, 3 bathtubs paid for to be replaced. They only replaced one because the other 2 were fine, nothing wrong. But the insurance company said, nah, there are going to be problems. It was root invasion under the house by the neighbor's trees. And so the neighbor's insurance company ended up settling with our seller a couple of years before he sold the house and wrote him a big fat check. Our seller went and hired a contractor who said, nah, you don't need to do that. Nah, there's no problem here. Nah, you don't need to do that. Well, after he sold the house a year later, some of the things he didn't fix became problematic. And so that was a bit of an issue. So hopefully you understand that. It makes sense. And I explained it well. If you didn't quite get it, probably I didn't explain it as well as I could. Don't hesitate to ask a question. That, what we've done to fix it. That wraps up our presentation today. I want to thank everybody for being a part of this presentation. And Lindsay?
Yeah, so we have a couple questions. Drew is wondering, on flip properties, is there any other disclosure if we helped the buyer acquire the flip property and then represent them on the relist?
So so this is a flip property that's not an in-house sale, if Drew's on the line. So yeah, okay. Yeah, no, I mean, you want all of the normal disclosures, and in addition, you want the things I itemized just a moment ago, and that is you want and by the way, most flippers will initially tell you no. You want all of
the question I had was,
Yeah.
if we represent the flipper who acquired the property,
okay,
they do their work and then offer with us to relist.
right,
Obviously, there's all of the disclosures the original seller gave,
right.
that we're already asking for. But is there anything else we need to do? Because you've got possible dual agency there.
And you're not and it's not a dual agency. You're not representing the buyer of this flipped property. You're representing this flipper.
Correct. But then
Right.
What happens if we get someone who does want us to represent them as the buyer?
Right. Well, the reason I separate that
you
is,
get these long connected.
sure. The reason I point that out is advice. We have an absolute duty to advise our clients. That's documented over and over again. A lot of lawsuits hinge upon the, failed to protect us, failed to advise us, failed to guide us. Well, if you're my client and I fail to give you, reasonable advice, and by advice isn't telling them what to do, it's telling them their options and perhaps their consequences if they choose option A or option B. That's advice. Advice isn't telling them what to do. All right. We have zero obligation to advise a non-client. So the reason I asked that question is, if you're representing a seller, then if the buyer doesn't want to get any of these inspections and it's ours and the seller is not an in-house agent, we don't have the E&O to worry about. You have no duty to advise the buyer. You need to get a physical inspection. Now, if you also represent the buyer, or another agent in our company represents that buyer, then it's dual agency. And then we're going to want the agent representing the buyer, either you or the other agent, to advise the buyer. You should get an inspection. You should keep in mind that the seller may not be aware of all these problems. You don't need to all the problems that the property did have. You don't need to say that if you don't represent the buyer. But you were right on when you said, yeah, you've got to get all the paperwork that the flipper, your client, who is now the seller, obtained when you helped them buy the house. And I'm hopeful that he's professional and is willing to give it to you. If he's not, then you've got to have a conversation with him. Unfortunately, you have to give it to him, because if it's been within 3 years, we have it and we can't withhold it. That's that'll sink us right there. So hope that answers your question, Drew. I see your note said you got it. Okay, good.
Thanks, Walt.
Yes.
Bob asks, is there a risk that the lender sees this fully executed contract with addendums and asks for the inspection since it is part of the contract, then decides to have certain items fixed before they will lend on the house. I think he's talking about those inspections that are on the supplement.
Right. Well, in all probability, the lender's never going to see the inspection reports, because there's simply, now there is a good point, and not the first time, by the way, I'm thinking about this now. I think I've been asked this question before, and you have to deal with it by case basis. But if the buyer is not going to be getting an inspection, the fact that he's been advised to get those inspections, the lender's not going to have any problem with that. I can see what Bob is saying. If they say, yeah, I want this inspected, and this inspected, and then the lender sees that, then the lender's going to say, okay, we want those reports. And then the buyer says, I'm not going to get these inspected. It's kind of problematic. So maybe for that reason, be very open-minded. If the buyer says, I don't want any inspections, but later he says he wants one, well, I would argue he gets one anyway. I mean, within the 17-day window, whatever his contingency period is, he's not bound by bound to not getting inspection because he didn't ask for it. So I'm sort of correcting myself. I'm thinking maybe you don't put, yes, I want all of them if you don't know. Maybe you just don't put them if you don't know. So that way your lender doesn't freak out.
It's for those of us that came out of the short sale era in 2008, and we were putting it, and we could be going back into a similar situations, who knows? But I'm just saying that we learned not to put it and check the box, buyer to do a home inspection. They'd still do it anyway. And because I had represented buyers, and before we could even own the house, we had to fix fascia boards. We had to do all kinds of stuff. Now, this is if you're selling a house that's kind of where a family member doesn't have any equity in the house and a relative, and you're not going to do the work. So it's excuse me. They don't have the cash up front, and all their money is in equity. That's what I meant to say. And when they saw that, then we were required to fix a fence. And we were required to fix the fascia boards, and they had pulled up the carpet because the carpet was disgusting, and the lender made us put carpet in. So that's what I'm asking. Is this a flag potential, a risk? And if so, I guess the risk is worth taking so that we don't get sued.
I like your last statement. I would concur, but I'll soften up the pickle you're in two ways. One is, I can't remember having a problem with a lender, and in, 2/3 of this company, we've been using these forms for more than 10 years.
Okay.
So it's not, but I see your logic. But I'll also say to you, if the property does have serious problems, you're probably going to have that noted on the appraisal anyway. So the appraiser is going to, be the one that's saying, oh, no, this is falling down and that's a problem and this has to be replaced. So on a case by case basis, we'll have to deal with it. But I don't think it's going to be a big problem. If it is, and we have 2 or 3 deals falling apart because of it, I'll go back to E&O and talk to them about it, because if we can't sell real estate, we can't pay insurance premiums. So they got to let us sell.
All right. I like that. Thank you.
Yeah. Okay.
Sissy has her hand up.
Yes, hello, Walt. Hello, everyone. The question is, the question actually is on seller property questionnaire number 5. If it's a traditional sale, it's no relative or for ourselves or flip, and you're representing a seller, after how many years they still they're supposed to have all the disclosures and reports? Is there a certain number of years that they must have previous reports and disclosures?
Well, there is a minimum number of years that they must, and not so much them, but us if we represented them in the acquisition. So DRE regulations require us to keep all property transaction records for 3 years. So if we represented the seller when they bought the property and the seller threw everything away, we still got to provide what we have. And in fact, TCs and agents have learned to ask Lindsay, I think usually is when they ask, to, and now with Agent Hub, I think you can get it yourself. But in the past, please provide us all these items, because they bought the house 2 years ago. And so whether the seller has it or not, if it's within 3 years, we have to have it. The SPQ states that the seller must provide any reports or disclosures that they have in their possession. So if you have a seller like myself who never throws anything away, I probably got the physical inspection of the house I bought in 2006. I don't know if I could find it or not, but so if they've got it and they can put their hands on it, they need to provide it. If they don't have it and they don't have a clue on where it is, and it's more than 3 years, they can say, gee, I don't even know for sure if I have it. I frequently keep stuff like that, but I don't know where, and I looked around, I don't find it. You can't provide what you don't have. So I hope that answers your question, but
Yes,
the
thank
short
you.
answer is for 3 years, whether the seller has it or not, if you represented them when they bought it, we have it. For any reports the seller has, if he got them in his possession, he's got to provide them. That's what the contract says.
All right, thank you.
Now, by the way, that's a great question though, because what I didn't bring up, and I should, when you provide old reports, it's critical, and old disclosures, it is critical to do that with a cover sheet that makes the following statement, and that is, these were the disclosures and reports the seller got when the seller acquired the property. All right, that explains it. These are not ones the seller's making now. These were made when they acquired the property. And then the next statement, and my wife's at TC, she puts this in bold. The information contained within these disclosures and reports may no longer be accurate. Now, when I talk to agents and principals, they love that statement because, yeah, I fixed that. I mean, I know that my inspection report from 3 years ago said the roof leaked, but I put a brand new roof on. Well, I'm not too worried about that. Nobody's going to sue you because you said the roof leaked and it doesn't. You're not going to get sued for that. So the fact that the seller fixed any of that stuff, they want credit for it because they're afraid it'll tarnish the deal, but they're not going to get sued for it. I'll tell you where they will get sued for it. 3 years ago, the roof was fine. Today, it's a mess. You give them a report that says the roof was fine. Yeah, but it was dated 3 years ago. So we need to point that out. So that's why that second statement, the first statement, these are the disclosures and reports the seller received or obtained when the seller acquired the property. Then the next statement, and make that bold, the information contained within them may no longer be accurate. And you don't need to say this out loud, but legally what you just said is the fact that this report says the roof is fine, that may not be true. Of course, if the seller knows the roof's not fine, he would disclose it, but the seller may not know, it was fine when he bought the house. My roof was fine when I bought it in 2006. I'll bet you in 2021, when I replaced it, it wasn't so fine. But I didn't know. Okay. I hope that answers your question, Sissy.
Yes,
That's
thank you
all,
so
Walt.
much.
Those are all the questions.
All right, folks. Thank you very much for attending today. I appreciate it. If you have any questions about this, don't hesitate to call me. Be sure that you do follow these guidelines to make sure your transactions are covered by E&O if you are selling agent-owned, relative-owned, or business entity-owned properties. Have a great rest of the day.
Thank you all.
Thank you
Thanks,
so
Walt.
much.
Thanks so much, Walt.
Thanks, Walt.
You're welcome. You're welcome. Thank you.